Welcome. I am Andrew Budraka, a partner at Morgan Lewis, and today I'm joined by my colleagues, Matt Schernicke, Andrew Rocks, Jackie Hamilton, as well as Luke Arsenault and Guy Knupp at Moss Adams, who are both partners at Moss Adams. We have a great collaborative presentation for you today on a trending topic of Paycheck Protection Program loans in merger and acquisition and investment transactions. These loans are turning up everywhere in deals, and this will continue to be an issue for some time that all of us will face. First, a note on format. Please use the Q&A chat function to submit any questions that you have during the program, and we will make an effort to sort of sort through them and answer them at the end of the formal presentation. So we hope you will appreciate the thought leadership and the intellectual effort and expertise that our two firms have brought to this multifaceted topic, and that you will think of us for your due diligence, structuring, or negotiation needs when you face a PPP loan in a transaction. Before I hand this over to Matt Schernicke, who will supply the significance and the context for our discussion today, I will read an all-important legal disclaimer fit to be read by a lawyer. The material appearing in this presentation is for informational purposes only and should not be construed as advice of any kind, including without limitation, legal, accounting, or investment advice. To be serious, though, this analysis of PPP loans is heavily factual, and it can pull in all sorts of considerations from technical regulation to enforcement and public relations risk and other angles. So if you need applied advice, please reach out to us. So with that, Matt, please take us out.
Thank you very much, Andrew. It's a pleasure to be here with everyone today, my colleagues and our colleagues from Moss Adams, to speak about this important topic. I feel much better now, by the way, that nobody will rely on anything I say during this session. So thank you for that. What brings us here today? Well, the needs of our clients and the fact that as of the most recent tally, there are over 5 million PPP loans that have been made. That's right, 5 million. That's a lot of loans made by over 5,000 lenders with an average loan size of only $101,000. So many of them are quite small. And the aggregate value of all of these loans together, over $525 billion. A tremendous amount of money has been spent in PPP loan processing, and the process has been nothing but challenging for so many of us. And one of the things that's come to light, and one of the things we at Morgan Lewis certainly realized early on, is that given the volume of loans in play, there would be a real effect on the merger and acquisitions process, because so many loans are out there, so many potential target companies have PPP loans, that given the size and scope of the program, how quickly it became prevalent among so many different types of borrowers, and given that these loans are, as we'll touch on a little bit further in this presentation, forgivable, meaning that they don't have to stay around forever or get repaid, we knew that there would be an effect on how people run their M&A process, and that indeed people would structure transactions in a manner in which they could maximize the extent of forgiveness or try to preserve forgiveness, rather than have these loans paid off at the time of the underlying M&A deal, which is distinct from how a lot of other debt would be treated in structuring an M&A transaction. And so that is what brings us here today. We don't have a lot of definitive or new guidance from SBA on how an M&A process ought to operate relative to PPP loans. Thus, we are all in the market interpreting existing guidance and procedures and trying to apply it to an M&A process that is inherently fluid and in which market participants are looking for our guidance collectively from tax, legal, accounting, et cetera. And so without further ado, I'd like to turn it over to Luke to talk through the basics of the PPP program.
Thanks, Matt. and Andrew. As mentioned, we will be focusing on the impact and merger and acquisition, but we thought about just a quick reminder overview before starting. So the Paycheck Protection Program under the CARES Act came into law on March 27, and that's already 5 months ago, so time flies. As alluded earlier, the program had $669 billion of business loans and was implemented by the Small Business Administration, the SBA, with an initial deadline of, if you remember, June 30th, which deadline was extended to August 8th. So, as a reminder, the loan at a really high level, the loan amounts were based on the average 2019 payroll, the monthly payroll, times 2.5 to a max of 10 million. The loan forgiveness guidance under the PPP is really in the PPP Flexible Act, which came out on May 28th of this year, and requires that payroll costs account for 60%, at least 60% of eligible expenditure, and other forgivable covered costs can make up the remainder, up to 40%. On the next slide, the Flexible Act provided more guidance. For example, the forgiveness period is the earlier of 24 weeks after the loan origination or December 31st, 2020. And there's an election for loans that were made before June 5th to keep the original 8-week forgiveness period. But again, the borrower needs to make an election. The PPP Flexible Act also provided a number of safe harbor provisions, which we have a few on that slide. So we'll now dive into the M&A impact, and I'll turn it to Andrew to guide us through a few slides. Go ahead, Andrew.
Thank you, Luc. My name is Andrew Rocks, the other Andrew joining you today. We'll now turn to common themes and points of negotiation that arise in M&A transactions involving a PPP borrower. So the critical decision point, and the one with the most issues surrounding it, is how to logistically treat these loans in connection with the deal. Should it simply be treated like debt and paid off, or should the loan be kept in place in order to accommodate forgiveness? It is this forgiveness feature of the PPP loans that has proven to make this a complicated analysis, including conflicting motivations, unclear guidance, and the potential for conditionality and delay. While loan forgiveness is obviously an integral component of the relief program, the logistics involved in accommodating forgiveness might push parties toward favoring repayment. So what are some of the issues influencing this decision? Well, the parties should first look to the terms of the PPP loan and the governing loan documents to identify what is permitted. Under the documents, would the transaction be considered an event of default or otherwise require the consent or waiver from the PPP lender? In addition to any lender consent or waiver, will the prior consent of the SBA be required? And finally, what are some of the timing implications for seeking these consents, and how does the forgiveness process affect the transaction timeline? We will explore these and related issues in more detail. As mentioned, a threshold issue is what the terms of the PPP loan provide. As a reminder, the PPP loan program has been promulgated as part of the SBA's existing Section 7A loan program. And so the SBA has utilized its pre-existing forms and operating procedures for the 7A program to facilitate these loans. Under the 7A loan form of note, a borrower is in default under the note if it has any adverse change in financial condition or business operation that may materially affect its ability to pay the loan, or if it merges or otherwise changes its ownership or business structure without the lender's prior consent.
This broad formulation would require lender consent for a wide range of M&A transactions, including both equity and asset sales. Of course, a PPP lender may choose to use a different form of note, so parties should be sure to check the precise terms of their relevant loans. On the question of SBA consent, SBA loan servicing guidelines provide that transactions require a lender to obtain the prior approval of the SBA with respect to certain transactions. In other words, the lender is not permitted to unilaterally consent to certain transactions without first going to the SBA. Such transactions include any proposed change in ownership in the first 12 months after loan disbursement, or any transfers of at least 90% of the loan and/or a release of the original PPP borrower. In practice, seeking such SBA consent does entail some lead time, sometimes as long as a month or even longer, which is likely especially true in today's environment. So parties should be mindful of the potential delay. I'll now quickly turn it over to Matt to go over how market participants have been reacting to and viewing these consent requirements and the related risks.
Thank you very much, Andrew Rocks. So as Andrew mentioned, one of the things we've observed is that there has been a lot of activity related to PPP loans in the context of M&A transactions already, but the market practice has not been consistent. And indeed, people are trying to find solutions to deal with these loans and preserve them, recognizing fully that there may not be a perfect answer, given that, as I said at the onset, SBA has not provided new definitive guidance relative to the appropriate treatment of these loans in the context of an M&A deal. So we view this as a question of risk tolerance and liability. And our next slide, and indeed I think it's okay to flip to that slide, shows our risk spectrum. Or if you'd like to color scheme it and make it pretty, you could call it the risk rainbow. But for purposes of this presentation, we're looking at it as a spectrum of risks. And this is meant to be only an indicative example of some of the loan scenarios that might cause lower risk in an M&A context versus higher risk. What is certain is that certain core factors would be relevant to this analysis in all cases. One of them is in what state of play is the underlying PPP loan? In other words, have all of the proceeds already been spent and has a forgiveness application already been submitted for approval? Indeed, that could be the case now because some borrowers borrowed in the very beginning of the program and should have theoretically already been able to submit forgiveness applications. Alternatively, has the borrower not spent all of the funds and therefore it still got to process the remaining funds and then potentially later apply for forgiveness? Well, that's a very different profile in relation to the risk M&A deal than if the money has been spent and forgiveness already applied for. That is one core consideration that we've analyzed here. Another couple of examples of risk factors that we think would have to be taken into account include whether or not the size of the loan exceeds $2 million, which is a threshold of value that at least SBA has indicated puts it into a box where it is not going to, if it's less than $2 million, it's not necessarily going to be subject to audit requirements, and the necessity for taking down the loan will have a different profile from at least SBA's perspective. But if it's a larger than $2 million loan, there are different questions surrounding that loan. For example, it is more likely to receive a greater degree of scrutiny if SBA uncovers that a change of control transaction perhaps has occurred with one of those loans in place. And so we do think that the size of the loan is another factor that would be weighed in the risk spectrum. One other is which parties are involved. For example, are we dealing with a private equity-backed target company that took down the loan in the first place, which may have had capital to infuse into the underlying PPP loan borrower? Would that make that a higher risk scenario than, say, a small company that took down a small loan and could very easily demonstrate need at its certification and application process? We think it does increase the risk of scrutiny and dealing with this in the context of M&A. So again, all of these factors would be weighed, and looking at the risks, will have to be done as you evaluate the structure and how much risk are you willing to take as a party to a transaction. We also think that certain parties are somewhat removed from the risks. For example, an incumbent lender to a buyer party, meaning the incumbent lender, not the PPP lender, but the buyer of a target that has a PPP loan in place, that may say, yes, it's fine for them to go forward, do their deal, knowing that there's a PPP loan in the target. We think that that lender consenting in that context is somewhat far removed from the underlying risks attendant to doing M&A activity around PPP. Not free from risk, but somewhat more distant from the underlying loan risks that we've contemplating. So again, evaluate all of these factors, and then we'll move forward to, again, Andrew Rocks on some of the other considerations as we evaluate structuring these transactions.
Thanks, Matt. The next few slides synthesize how these issues discussed thus far impact borrowers/sellers, buyers, and then lenders. So sellers are obviously focused on the impact of all of this on their proceeds in a given deal. We are seeing most sellers push back on proposals to treat the PPP loans like normal debt and to have them paid off at closing. Sellers want their forgiveness, and they are either pursuing structuring alternatives or in some cases even delaying deal timelines in order to accommodate forgiveness applications, which Jackie will discuss more in a minute. In any event, borrowers should go into an M&A deal understanding the consent requirements under their own loan documents and the potential impact they have on a given deal timeline. Buyers, on the other hand, will almost always favor the repayment of PPP loans at closing to acquire the target on a debt-free basis. Doing so saves them the headaches involved with seeking forgiveness, as well as the added benefit of a reduced risk of future scrutiny regarding the loan. These factors tend to outweigh a desire to secure forgiveness or to otherwise keep cheap debt in place post-closing. The impact of forgiveness on deal timelines will also be important for buyers. Per guidance issued under the CARES Act rules, PPP lenders have 60 days to approve a forgiveness application, and then the SBA, on top of that, has 90 days to approve and disperse the forgiveness amounts. Understandably, this potential 5-month process has a significant effect on a buyer's appetite to delay a deal for forgiveness. Buyers might also be particularly sensitive to taking on a PPP loan given the negative PR risk. If a buyer is PE-backed or otherwise has ample access to capital, it may not be interested in taking on a PPP loan in its structure. On this point, based on current guidance, there does not appear to be a legal basis for the eligibility and necessity certifications made at the time of the original loans application to be reevaluated or, quote, brought down at the time of forgiveness. In other words, subsequent M&A activity presumably should not affect eligibility for forgiveness. That said, there is nothing definitive from the SBA on this, and buyers should consider the spectrum of risk factors Matt discussed earlier in evaluating the risk on this issue. Finally, a quick note on lender considerations. As mentioned earlier, the requirement to obtain prior SBA approval for certain loan actions is a lender requirement under existing loan servicing guidelines for the SBA. The lender should carefully take stock of these obligations when a borrower requests consent to a transaction. Given the procedures involved, we have seen lenders seek reimbursement for costs incurred in granting its consent, including the work done to seek prior SBA approval. This includes reasonable outside counsel fees and the like, so just be mindful of that. I'll turn it over to Jackie to discuss some of the structuring alternatives parties might seek in order to accommodate forgiveness.
Thanks, Andrew. So once you realize that there's an outstanding, or once the buyer realizes that there's an outstanding PPP loan, parties are going to need to think about how to structure the transaction to deal with that loan. And so here we've got 4 options, right? So if the parties are amenable to either keeping the PPP loan outstanding until a forgiveness application can be filed, or otherwise factoring in the value of the possible PPP forgiveness amount to the transaction, there's a number of possible options as to how to handle this. So option one is the first option here is quite buyer favorable, and it's to simply wait until that loan is forgiven to enter into the transaction. Of course, while this is potentially risk averse, it will almost assuredly delay a transaction timeline. We're going to get to a timeline of forgiveness, but as Andrew mentioned, there's 60 days and then 90 days, so a total of 150 days. So you really are potentially going to delay your transaction by doing this. Option two, still buyer favorable, but a bit more neutral, and contemplates the parties are going to enter into the transaction agreement and then wait to sign the transaction agreement and then wait to close that transaction until loan forgiveness has been obtained or, in theory, denied. Again, a risk-averse option, but it does provide some additional comfort from option one in that seller understands that the buyer's entered into the agreement. So it's a little bit more favorable, but still, again, there's going to be a significant possibility of delay. Option three, fairly neutral option for both parties. It allows the parties to move forward with the transaction. So this is to keep the PPP loan in place post-closing. Of course, this assumes that you've obtained that required lender and SBA consent. It's good. Parties are going to move forward with the transaction and then allow the seller to seek forgiveness after the closing. There's a potential economic benefit to both sides in that the deal's closed, but there's still that potential of forgiveness. And then again, so finally, option four, it's a bit different in that it does not, quote, accommodate forgiveness, but instead contemplates that the full PPP loan is paid off at closing. It's going to be deducted from the purchase price, but then the purchase price is going to be effectively grossed up by some or all of that anticipated forgiveness amount. And just a quick note, we did not anticipate that option four would be widely used when we started thinking about this several months ago and when the forgiveness regulations started coming out. But we've actually seen a number of buyers and sellers go this route for various reasons. And just to say, the gross for the purchase price may very well be less than the anticipated forgiveness amount here. So for instance, if some buyers might be willing to split this with a seller. So an anticipated forgiveness amount of $1 million, if that loan's going to be paid off, both sides might agree that, there's going to be a gross of $500,000. So it's, you get half of the forgiveness. So it's still a pretty good deal for both sides, albeit not perfect. Next slide. Great. So the next two slides here are going to look very similar. They're illustrative timelines for option three. Again, keeping that PPP loan in place post-closing in order to accommodate future forgiveness. And the only difference between the two timelines is that the first is going to use, as you can see, the original 8-week forgiveness period, while the second, that we'll get to in a second, uses the extended 24-week forgiveness period. And taking a closer look at this timeline, we're making an assumption here for purposes of this illustration that the borrower uses that 8-week forgiveness period and does not enter into an LOI until after the PPP application was filed and the loan was funded. Just a really quick note on this, having an LOI executed prior to the PPP loan application being filed or the loan being funded is going to potentially raise additional considerations as to eligibility. So we talk about that a little bit more in the context of diligence, but just wanted to note that here. And so in this example, transactions of simultaneous sign and close, it's executed immediately following or on the same day as the filing of that forgiveness application, in this case, July 15th. And then noting again that there's this 150-day review period, the outside date for forgiveness is December 12th. So just taking a look, if you sign an LOI on June 1st, you do get the benefit of being able to sign and close the transaction in July in just about 6 weeks, but you are, waiting until December 12th or you could be waiting, I should say, until December 12th to recognize whether or not forgiveness is going to be granted. One thing to note here, and I think it was alluded to earlier, is that while the SBA has opened its portal for lenders to submit forgiveness applications, because it goes from the borrower to the lender, and then the lender makes a decision and it goes to the SBA. While the SBA opened its portal in early August, many lenders have actually not yet started accepting forgiveness applications. They're continuing to develop their own portals. They're waiting for additional SBA guidance on this. So just note, while we have July 15th as an illustrative date here, it's unlikely that anyone was able to apply that early. go to the next slide. So as I mentioned, very similar, almost identical to the prior timeline, except this assumes that the borrower uses that extended 24-week forgiveness period. In this case, the transaction signed and closed on July 15th, but that 24-week forgiveness period does not end until September 30th. So then you file that forgiveness application on September 30th as soon as you can, which, as I mentioned, this is actually plausible. People should be able to file by September 30th. And then 150 days later is February 27th. So you're actually into a new year. So again, thinking about this, you sign an LOI in June, but you don't know yet if you're going to get forgiveness until February of the following year. So the point here that we're really trying to drive home is if the parties had elected to wait to sign and close the transaction, so options 1 or 2 in the initial slide, they would be waiting, several, perhaps weeks, but probably more likely several months. So trying to structure around that, I think, is really key, and one of the many things to think about up front. Next slide, please. So assuming, again, that the parties chose option 3, allowing that PPP loan to remain outstanding, there's a few possible options for the treatment of the potential forgiveness amount in a transaction. So the baseline principle here is that the PPP loan balance will be treated as indebtedness and deducted from the purchase price. Note the PPP loan balance is not necessarily being paid off at closing, or it's not being paid off at closing, not necessarily. It's not being paid off at closing. The indebtedness amount is held until a forgiveness determination is obtained. And so to dive in, as is evident on the slide, we're going to go from pro-buyer option to pro-seller option. So this first option is very buyer favorable and contemplates the buyer will pay to the seller any forgiveness amount that's subsequently obtained. This means that the risk that the loan is not forgiven is going to be borne entirely by the seller. Any portion of the loan amount that's not forgiven will be paid by buyer out of the amount that they deducted from the purchase price. And of course, if the loan's not forgiven at all, the seller gets nothing, and the buyer simply repays the lender. So the forgiveness amount here is not placed in an escrow, so the seller is going to have to trust. Of course, there's a contractual arrangement to do this. The seller is going to trust that the buyer will remit any forgiveness amount to the seller. And speaking about escrows, option 2 is nearly identical to option 1, except that the maximum forgiveness amount is placed into a third-party escrow account. So for all the reasons that people use escrows in transactions, I think this is probably a more common option that we have seen people think through. So if and when forgiveness is obtained, the forgiveness amount will be released to the seller, and then any portion of the loan that's not forgiven will be repaid with the amount held in escrow. And then option 3 here is a more seller favorable option and contemplates that while the buyer will deduct the PPP loan balance as indebtedness, there's a credit given to seller at closing for the expected forgiveness amount. So the risk of forgiveness here is largely borne by the buyer. As an example, just to walk through some numbers very quickly, if the PPP loan is $1 million and the expected forgiveness amount that parties have done their diligence and kind of agree on is estimated to be $800,000, the parties might agree to credit up to $800,000. However, it might be discounted back to something like $500,000 or $600,000 for the risk of denial, tax adjustments, etc. And then if and when that PPP loan is forgiven, the amount will be paid back to buyer. And then an additional option here, call it 3A, if you will, would be that the acquisition agreement provides for a post-closing adjustment to true up that forgiveness benefit if the maximum forgiveness amount is not approved. So the parties had agreed to a credit of $800,000, but only $600,000 was forgiven. The agreement might provide that seller must pay to the buyer or to the lender on buyer's behalf all or some portion of that difference, the $200,000. Next slide. So then thinking about this, so everything we've been discussing thus far has really, been change of control transactions through the lens of mergers and equity purchases. But this is, it's an M&A presentation for a reason. There's several considerations to think through for asset sales. The key one, the first one off the top, is whether or not lender consent is going to be required under the terms of the PPP note. And so this is, of course, specific to an individual borrower's note, but selling substantially all of the assets will generally require lender consent. And I think we're we're comfortable saying that the typical form of 7(a) note, which many lenders, certainly not all, but many have used, is going to require lender consent. Typically, though, where that loan remains outstanding and the borrower is not being released from the loan obligations, SBA consent will not be required in an asset transaction. So this is an important point. There is some thought out there that this could change, that the SBA might be creating some new guidance on this. We have not seen anything from the SBA on this that would change this. And so the way that we're reading those regulations is it's not required for the lender to seek SBA consent. And again, since SBA consent can sometimes take a significant amount of time to obtain, this could be a potential consideration to use an asset sale structure. Of course, there's all sorts of considerations as you're structuring a transaction, but if a loan is large enough and there is a significant likelihood of forgiveness, this is one that, something to think through. And then one of the other the key points here is where the PPP borrower is in the process of utilizing the PPP loan proceeds, right? And what we mean by that is if the loan proceeds have been spent prior to closing the asset sale, the seller borrower's eligibility for forgiveness should not be impacted. As Andrew Rocks mentioned, there is no basis currently for a bring down of eligibility or necessity. So once those funds are spent, you are sort of in that forgiveness window. You can apply for forgiveness regardless of that asset sale. However, if a borrower has not utilized all of the PPP loan proceeds and then sells substantially all of its assets and transfers its employees, it's knowing what we know about the PPP, it's unlikely that the borrower will be able to utilize the loan proceeds for permitted uses following that asset sale, right? There's limited permitted purposes. And so if you don't have employees, you don't have assets, it's going to be really difficult to fit into any of those purposes. So with that said, it might be helpful, continuing the theme of waiting here, unfortunately, it might be helpful to wait to execute on the asset sale until the loan proceeds have been used. Again, not to say that asset sales are better or easier, but they should, in theory, not delay timelines as much, given that SBA consent should not typically be required. And so with that, I'll hand it off to Guy Knuff to talk about the effect of PPP loans on net working capital.
Thank you, Jackie. So now we're going to explore the, as Jackie mentioned, the effect of the PPP loans on net working capital and EBITDA. And very interestingly, most M&A agreements call for a provision for a PEG, for establishing a PEG for net working capital. Under the impact with PPP loans and COVID, we now need to define or determine how we're going to define our normalized net working capital. That historically we've used a trailing 12 average, and that may not be representative of a net working capital without some normalized adjustments that may need to be made. And so, typically net working capital is in its simplest form, current assets minus current liabilities, and it's an amount of working capital that the seller is usually required to deliver to the buyer. And so we're going to explore in a little more detail, not complete, but in some detail, go over some potential things to consider. And then also we're going to explore EBITDA considerations. And again, EBITDA is earnings before interest, taxes, depreciation, and amortization. And it's very important because it's a driver in determining many of the purchase prices. And so we're going to explore the accounting for the PPP loans and the potential forgiveness and how that may impact valuation considerations. And then lastly, we're going to just attempt to make you aware of some of the tax considerations that you may need to consider while in the M&A process. So let's move on to net working capital. So as mentioned, traditionally we've used a trailing 12-month average of net working capital as a baseline for determining our PEG. with certain impacts in COVID, we're going to need to explore a little more closely some of our business trends and net working capital accounts. For example, there's certain delays in collections and defers and payments. And so instead of having a standard monthly net working capital, we may have had, it may be rather lumpy, and we may have months where it's very high and months that are low, and we're going to need to explore as to why. Things like the treatment of the deferral for payroll taxes under the CARES Act, or the treatment of the deferral of rent. You know, in some cases that impact may be with rent, it may be temporary, or it may be a permanent change. Many companies are looking at, you know, and exploring their real estate rental footprint that has existed, and you know, now with everybody working at home, they might be re-exploring as to the changes where everybody comes back to work, or maybe that changes. So that has to be considered. Also, consider the PPP loan proceeds themselves and how they were received. Again, you know, some of the funds were obviously intended to keep people working and for companies to be able to pay their payroll, but you know, some of those funds were used to pay past due accounts payable. And so we need to consider the impact on those types of payments that were made on net working capital as well. And again, you know, it kind of comes down to normalizing the operation level. You know, what did the company look like pre-COVID? Where are they now? And then what's the new normal going forward? And, you know, having to consider things like a deeper analysis into the customer's receivables. You know, understanding you're starting to hear more companies filing for Chapter 11, and what type of risks do we have in certain asset classes that may have been had less risk before COVID as compared to now. And so again, I think Jackie mentioned the debt-free, cash-free. We have to look at, you know, if there is no forgiveness and this is going to be treated as debt, or until it is forgiven, treating it as debt under cash-free, debt-free. How do we account for that as well under net working capital? So these are just a few examples. I think the overarching concept here is that net working capital typically was a consideration that was brought up kind of downstream. Accountants are always calculating it, but it usually was brought up downstream in the process. And now, because of certain considerations, we need to be mindful of trying to calculate it sooner in the M&A process and come to agreements as to how we're going to characterize certain things. So maybe let's move on to EBITDA and certain considerations. We're going to focus on just a couple here. There could be many more. But how does the PPP loan impact EBITDA? And, you know, as we were talking, or you're hearing about forgiveness, you know, there's been a lot of talk as to how that's going to be properly recorded in accordance with general accepted accounting principles on your financial statements. And the way that it's recorded may or may not have an impact on your EBITDA. The forgiveness of a gain, you know, it makes sense that should be a reduction to your payroll and offset. But then again, the use of these proceeds there may have been excess, and some of these proceeds might have been used to invest in the company, or used in a manner that they may have created a non-recurring investment, or analyzing whether it was a recurring investment. So we're going to need to analyze that a little deeper, and the impact of that on the valuation driver of the company. And then lastly, really just considering the normalizing EBITDA for the temporary impact of COVID. Many examples of transactions right now is you have companies that are in situations where they're below a standard run rate, And then, in effect, you've got companies that are in excess, depending on what they're producing. And we need to look at, if you're manufacturing sanitizer or gym equipment, what really is the potential future, the new normal of sales for those things? Are they going to continue in the future, or was there a significant increase because of the current environment and demand by customer base? So deeper considerations in the value driver. So last week, want to go over a few considerations, just important things that we want to make you aware of. And kind of the disclaimer on this is really, these are things that you should be talking to your M&A tax advisor and your tax preparer. But the first one is that I'd like to cover is the actual loan forgiveness. Many people are aware that there's forgiveness for federal purposes, but they're not aware that potentially it could be taxable for state tax purposes. So that's something that you need to investigate. The employer portion of the Social Security tax deferral is available until the loan forgiveness application is approved. And then there's certain tax credits out there. There's actually a tax credits for those that did not take PPP, employee retention credit. That is not available to you if you did take a PPP loan. Other things like the family leave credit and the paid sick leave credit, there's really no double dipping, with PPP forgiveness. And then kind of lastly, just mentioning it's a time to revisit all the elections you made for 18 and 19 that you filed on your returns, because if you've incurred if you're very profitable and now incurred a substantial loss, there may be an opportunity for you to excess business losses and net operating losses to be carried back. And then lastly, qualified improvement property and interest expense limitations need to be looked at as well if they apply. So Jackie, I'd like to return it to you, and I think your next is going to the CARES Act and other PPP considerations.
Sure. And should I go ahead and read this, the CLE Alphanumeric Code?
Okay.
So you're going to need this code to receive a certificate of attendance. And so for those seeking CLE credit, please keep the following alphanumeric code for your records. It's HDR 778W. Again, that's HDR 778W. So thanks again, guys. So the next couple of slides here are focused, and I alluded to this earlier, on key considerations in thinking through due diligence when there's a PPP loan outstanding. And so at the outset, because this is a federal loan program, there's going to be specific implications that are likely new for many parties, both buyers and sellers here, that really would not otherwise, the seller would not have otherwise taken a federal loan. The buyer, particularly PE buyers, probably wouldn't be looking at companies that have outstanding federal loans. As Matt mentioned, there's something like 5 million PPP loans. That is just a totally different ballgame than we were in any prior period. It's a large number of loans for people who otherwise would not have been part of the federal loan program, and so this is kind of new for a lot of people. So really need to dig in on this diligence in a way that it's not just typical indebtedness diligence. And so once a buyer determines that a target has an outstanding PPP loan, they're going to need to understand the specific details of that loan in order to make a determination as to how the parties will want to treat that loan. So again, going back to all the things we discussed, you have to understand whether there's a loan and what the documents say. And then the amount of the loan is obviously important for several reasons, not least of which is the fact that there's a safe harbor of sorts for loans under $2 million, right? And so back to one of Matt's slides earlier in the presentation, one of the things that we consider to be, quote, risk, again, not an undue risk, but a risk of sorts, is loans above $2 million. So you certainly want to know, of course, how big that loan is and what the structure is. And buyers are also going to want to review and ask questions about the borrower's eligibility and necessity certifications And if anything seems off about that, they're going to want to have a record. And then in the event that parties are, of course, planning to seek forgiveness, the buyer is going to want to make sure that they agree with the seller as to the potential forgiveness amount. So there's a complex calculation of sorts, and then, of course, taking into some tax considerations there as you calculate what that forgiveness amount looks like. And then, again, given that this is a federal loan program, a buyer is going to want to confirm that sellers, directors, officers, and employees are not prohibited from engaging in any government contracting activities. So while that piece may be standard due diligence, it's particularly important here. And please go to the next slide. So again, this is sort of all under the backdrop of potential False Claims Act enforcement. There's potential criminal penalties and false statements and civil liabilities. Again, this is where it really is very different than a typical indebtedness diligence exercise. And then we mentioned here that you can bolster your compliance with laws rep. There's many ways to do that. In any event, I think parties are really going to likely want to build these diligence considerations directly into a transaction agreement. And so again, whether that's directly into the compliance with laws rep or the separate COVID rep or a federal funding rep saying there's no other federal funding except, on a schedule, and then having specific and very detailed in many ways representations about each of these items. And so if you do have questions about this, we're of course happy to help. Fully engaged on this. And so with that, I will turn it back over to Luke to discuss some additional diligence considerations.
Thanks, Jackie. So we'll quickly go through the next two slides to allow as much time as possible for questions. So I'll go through these quickly. Just a quick highlights of what we've been seeing on the financial due diligence side, working with our clients since COVID-19. And one area is a definite, much deeper look into cash flow. So, going all the way to free cash flow after EBITDA, and also short-term cash flow forecasts, and at times even weekly cash flow forecasts. We've also been asking, looking at much more modeling and sensitivity of plus and minus, including, if there's a second phase and a big shutdown, how would it look like? And on the next slide, so the sensitivity and the modeling is a bit like Guy mentioned, really dives into the client slice of, type of client, industry, and even geographic area, just to consider the risk. And another aspect of where we've been really performing a lot more analysis compared to prior years is just on the cost structure flexibility. Buyer really wants to have an in-depth understanding of the fixed versus variable costs, really in the perspective of how quick can they scale up and down if ever there's another shutdown and a second wave. And that's preoccupying buyers to see if how quick they could reduce those variable costs. So with that, I'll turn it back to Andrew.
Thanks, Luke. In terms of potential recourse, buyers might seek around the risk we've talked about today. Buyers might seek fundamental treatment for any PPP specific or compliance with laws reps in order to avoid being subject to typical indemnity obligations. An alternative is to seek specific indemnities related to PPP noncompliance or to the forgiveness amount, particularly where issues have been found or where the buyer is bearing the forgiveness risk. Buyers should ensure that any indemnifiable losses as defined under an acquisition agreement include losses suffered as a result of any breach or failure to comply with the PPP, including the amount of any civil or criminal penalties. Escrow or holdback arrangements can, of course, be utilized to backstop indemnity obligations for potential PPP-related liabilities, especially where red flags have been raised on eligibility. A quick note on rep and warranty insurance. Parties should be wary of potential exclusions in the policies related to PPP matters. We have seen blanket exclusions for losses arising from just the use of PPP proceeds or the availability of forgiveness. But subject to the level of buyer due diligence around the PPP loan, insurers have expanded their exclusions more broadly to include all losses arising out of or resulting from any PPP loans. So be mindful of that if you're negotiating a policy in connection with your deals. On the next slide, in terms of covenants, where forgiveness is being sought, post-signing or post-closing, then the seller or the buyer, as applicable, should consider appropriate covenants to ensure proper efforts are utilized in seeking forgiveness. Parties should also consider whether to set up procedures for the control of any PPP-related audits and related cooperation, especially where risk of audit is higher, such as where loans are in excess of $2 million. And then finally, we provide this quick reference guide for the listeners to listing some of the best practices we've discussed today for each of the stakeholders, borrowers, buyers, and lenders. This will be available together with the rest of the slide deck on our website following the presentation. So with that, I'll turn it over to Jess to repeat the CLE code and then open it up for any questions.
Thanks, Andrew. So just one final time for all of our listeners. For those taking CLE credit, please keep the following alphanumeric code for your records. There should be a survey that will pop up once you close out of the window for you to enter in the following code, HDR778W. Again, that's HDR778W. Thank you.
Thank you, Jess. I guess it's back to me for our lightning round of questions. And we want to thank everyone who submitted questions. We have a number of them, so we're going to try to clip through these really quickly and get you some fast answers. So first, we have a question from listeners Greg Hurd and Matt Reber. Greg asks, changes in ownership? What about adding new shareholders as part of an internal growth round or other transition? Matt asks, does the lender and or SBA consent requirement apply to a minority investment, i.e. buying primary shares during the first 12 months, or just M&A or sale of shares by existing shareholders? Andrew Rocks, can you take that one?
Sure thing, Andrew. Technically, any changes in ownership, including changes in percentage ownership, are explicitly contemplated as part of the SBA prior consent requirements. But this all goes back to the risk factors we've highlighted in the presentation, depending on whether the change in ownership occurs indirectly up the chain of the PPP borrower, and how material the change is, whether it's only a minority change in percentage ownership or a majority change. We and other practitioners are seeking SBA guidance on this, as this obviously has extremely broad practical effects. And it seems to be, a ripe example of how the legacy 7A loan guidelines are somewhat incongruent with the PPP program, just because there are millions of PPP loans out there in the marketplace. And this is rightfully good questions to ask given the volume of them and how they might impact not only change of control scenarios, but also minority investment.
Thanks, Andrew. Next question is from Kurt Lentz. Kurt asks, is it even reasonable to assume you can get SBA consent to a transaction, that is, avoid being in default of the PPP loan in a time horizon that would accommodate an M&A process? That's a good question, and the SBA pace is certainly different from the deal pace. So Matt Chernicke, we've had some experience with this. Can you weigh in on this?
Sure, thanks. And hello to Kurt. It's good to see you appearing on our webinar. The answer to your question is it probably isn't reasonable to expect that SBA would respond to a change of control consent request in the time frame that a lot of deals need to move. In our experience with other clients in recent history, we have not seen anything with the speed that I think folks are more typically expecting when they approach people for a consent. And we do have to remember we're dealing with a governmental agency in this case and with a program that's new and which clearly, as to the 5 million plus loans, is dealing with tremendous volume. So the simple answer is no, I don't think that it is very reasonable to expect that change of control consent from SBA would be obtained or could be relied upon to be obtained in a reasonable deal time frame. I think that if it would be under 2 weeks, that would be, I think, extremely good and probably not expected, at least by the members of the phone call that we're having here. So I think you'd have to plan for at least a month and you might not get a satisfactory answer. And so that's also a very distinct possibility, which would mean you wasted time and may not have gotten the answer you want.
Thanks, Matt. Next, we have a question from Isaac Young. Isaac asks, in a transaction where the proceeds are not sufficient to pay off all debt, have sellers been prioritizing repayment of the PPP loan? Luke, would you take this one? Have you guys seen this?
Yes, Andrew, we've seen this, and I would equate it to it's been looked at just like a distressed deal where there's negotiation with the various lenders and all of the stakeholder of the companies before going to a prioritization. So it's much more like a distress situation.
Right. Thanks, Luke. And I think on this one too, it's not that common of a scenario that that debt is left in place in a deal. But if it is distress and that is the case, I mean, you'd be dealing with your regular priority issues and who's a secured creditor. Remember, the PPP loan is unsecured, so it would be behind any secured creditors, and you'd have to kind of sort that out in the balancing of those interests in a distressed transaction. Okay, next we have a question from Robert Donda. What are the additional eligibility considerations if an LOI is signed after the PPP was funded, after the loan was funded? So the short answer there, this is a quick answer, is eligibility is tested at the time of application, and so there is no need to reevaluate your small business eligibility at a later point in time. There has been some chatter on whether the forgiveness process will involve some look back or new look at eligibility, although we don't give much credence to that view given SBA practice and our experience. Okay, next we have a question from Diana Keneally. If an escrow is chosen for the treatment of forgiveness, typically is the escrow released at the time of forgiveness or after the audit period expires? Jackie, can you take that one?
Of course. Thanks, Andrew. And very good question. So this would be pretty aggressive from the perspective of a buyer. I think it would be fairly not uncommercial of an ask to delay it, to ask for that full audit period. What we've seen, I think, is the escrow is going to be released at the time of forgiveness. Within a few days, in fact, after the determination is made, is the provisions we've been seeing lately. Andrew.
Thanks, Jackie. Great. Next, we have a good question. It was not something we totally covered, and it is from Adam Heller. Adam asks, are we going to discuss the employee retention credit overlap? A buyer is planning to take a large employee retention credit, and the target has a PPP loan. Is pre-closing repayment, no forgiveness by the target, would that mitigate the tainting of the PPP loan on the ERC credit, i.e. there's no double dipping within the acquirer group. This is a great question. And if you are a PE firm and you have portfolio companies that are going to be taking the employee retention credit, and you come across a target with the PPP loan, you really need to stop and ask this question of yourself, because right now it is clear from the statute that an employer cannot claim the retention credit if an affiliate has taken a PPP loan. And this is different from the SBA affiliation rules. This is an IRS affiliation rule. And basically, any entity in which a PE firm or other owner owns more than 50% of the voting power or value, so you'd have to take into account any economic preferences that might kick you over a 50% equity value threshold, would be deemed to be an affiliate. And right now, the guidance from the IRS isn't clear enough to give comfort that your retention credits would be preserved if you bought a company that had taken and even paid off the PPP loan. So it's if the retention credit is an important economic benefit that you have in other parts of or other parts of the buy side, you want to be really careful about this. Currently, we're counseling sort of asset structures, basically not buying the equity of the PPP target to avoid this issue, but we're hoping for clarification. So it's a nuanced issue. Do reach out to us if you want to discuss it more closely. Okay, last question, and we're a little bit over time here, but we're going to get through all of these, is a question from Matt Schellinger. Matt asks, does requesting consent from your lender and SBA have an impact on the forgiveness application or determination? Said differently, should one apply for consent prior to forgiveness? Andrew Rocks?
Sure. So, very good question, and we've worked with clients on this one before. The short answer is there's no guidance, and so real no right answer on this one as to whether one submission impacts the other. In the absence of that guidance, it seems practitioners are proceeding with the understanding that both can be made simultaneous. But again, it's unclear how, once on the SBA's desk, how they're viewing one and or both of those submissions at the same time.
Thanks, Andrew. Okay, well, that's it from us. We're a few minutes over. I think we either covered any remaining questions with the topical information, or if you still have questions, all of us on this panel are available to answer your questions, and we hope you'll reach out to us if you confront PPP loans in your transactions and would like specific advice, either on sort of the accounting or tax or working capital side from Luke and Guy at the Moss Adams team, or from Morgan Lewis on the legal team. So thank you everyone so much for joining us today. We hope this was an informative presentation, and thank you. Have a great rest of your day.